Thanks a lot. Matthew Lee, Inner City
Matthew.
Press.
Yes.
On behalf of the Free UN Coalition for Access, thanks for this briefing, which I think will be the first of many in this venue. I wanted to ask whether the signing of the Fourth Geneva Convention, does this, some people have said that this makes it an ability to refer the situation to the ICC with whether or not you're a member. And I wanted to know if you have a view on that, and also whether these various, conventions on diplomatic relations, consular relations, do you have in mind of opening any new facilities, or does it change in any way your relations with other states?
Well, I will start with the second one. There are 5 instruments related to known as the Vienna instruments on the diplomatic and the consular relationship. We have about 100 embassies and consulate and diplomatic representations in all corners of the globe. Now, of course, most countries, when they have diplomatic relationships, they refer to the Vienna instrument in regulating the relationship between the two countries. In fact, some of the bilateral representation or relationship that have taken place between us and some countries, even before signing this instrument, these countries referred, and we went along with them in the memorandums or in the communique announcing the diplomatic relationship between us and these countries. There was reference to these instruments from Vienna. Now, we've done that before joining, and now the fact that we've joined, it solidifies the relationship between us and all these countries where we have representation based on this international instrument. Concerning, the first question,
whether joining the Fourth Geneva Convention means that a case could be brought to the ICC even prior to signing the Rome Statute.
Well, as you know, in the Fourth Geneva Convention, the convention was emerged immediately after World War II, and it is a cornerstone in international humanitarian law. And it is a significant instrument in providing protection for the civilian population, during the time of war and armed conflict. Now, the land of our state is under occupation. Now, Israel, it vacillates between accepting certain provisions of the Geneva Convention without acknowledging that it is an occupying power, but it is dealing with it in a selective way. Now, for us, of course, the fact that we will be that we are in fact now a high contracting party as a state, and our state, the land of our state, is under occupation, then all high contracting parties are under obligation, especially under Article 1, of respecting and ensuring respect of the provisions of the convention under any circumstance. It gives us an additional power and strength in really defending our nation, defending our state, and defending the land of our state, and demanding, ensuring the respect of protection of our civilian population living under occupation. And of course, that gives us additional strength of calling for meetings and what have you. Sometimes in the past, whenever we asked for the convening of the high contracting parties, we needed the General Assembly resolution to call for it. As you remember, in the past, we've done that. But now, as a high contracting parties, we have additional rights and privileges, among them, to call for the convening of the high contracting parties if one, such as Israel, the occupying power, is not honoring and respecting its obligation under the provisions of that convention. So it gives us a lot of additional strength. And when you say respecting and ensuring respect, it is an enforcement mechanism. Although this enforcement mechanism is not taking specific shapes, but resorting to it and going through it and demanding, enforcement mechanisms is a venue that is available to us. Yes, sir.